Representative Kislak has come, House Bill 5298. It's an act related to delinquent and dependent children proceedings in family court. It prohibits any questioning of a juvenile who is suspected of delinquency or criminal behavior unless the parent or guardian or the juvenile is present, or unless an attorney is present, or the juvenile and their parents have waived the attorney's presence. Bill's yours.
Thank you, Chairman and members of the committee. I am here again with this legislation, and I really hope that we pass it this year. Kids should not be questioned by the police without a parent or guardian. They just shouldn't be. Adults are adults and have more experience and can waive their right to an attorney. Maybe they shouldn't, but they are adults and we let them make these decisions. Kids should have an adult. It would be nice if they all had an attorney, but they shouldn't be questioned by the police without a parent or guardian. So that's the fundamental value of this bill. I have been before this committee enough times that I know what some of you are likely to say, and arguably this is already the law. It should be and is, I think, enforced by courts sometimes as being a fundamental constitutional right for children. I have heard that any evidence obtained like this might be thrown out, but it's not in statute, and we should codify this. You'll hear again, and in the ACLU's written testimony again, I think is probably the genesis of this bill, which is in a case that they handled where an 8-year-old was questioned by police without a parent, without notifying the parent, even after the initial possible threat that had been reported regarding this child was found to be not true. One of her classmates said she had something in her bag she shouldn't have. It wasn't true. 8-year-olds say things. Even after they searched the bag and it was found to be perfectly safe, they continued questioning this kid. They continued not notifying the parent. So that's the genesis of this legislation. We have heard in past years, and I'm not sure who's going to testify if there are going to be more news stories tonight, but we've heard in years past from parents whose kids have also been questioned by the police without notifying the parent, without trying to notify the parent. There have been stories about the police questioning kids without an adult or parent present when the parent was sitting in the police station demanding access to their child for hours. I don't think this happens very often. I hear a lot about the police getting things right, but sometimes they get it wrong. And people should have protections, and we should do it in statute. We should spell out in statute this year that kids have the right to have a parent or guardian present when they are being questioned by the police. And I hope you will join me in supporting this legislation this year.
Any questions of the sponsor? Great. Well, thank you very much.
Thank you.
And we have, let's see, 11 witnesses that wish to testify on that bill, but we'll get to them shortly.
You want to go next?
Thank you. Thank you to the members of the committee for allowing my testimony tonight. My name is Teresa Kamenos, and I'm here on behalf of Human Rights for Kids in support of House Bill 5298, which would prohibit the custodial interrogation of a child unless a parent, guardian, or an attorney is present. Just as a brief introduction, Human Rights for Kids is a national nonprofit organization dedicated to the promotion and protection of the human rights of children. We center our work on a human rights framework to highlight and better understand the connection between adverse childhood experiences and justice system involvement. This bill would address the important issue of protecting children's constitutional and human rights at the initial stages of contact with the criminal justice system ensuring that children have the right to consult with a parent or legal guardian prior to custodial interrogation, which will reduce incidents of false confessions by youth and better align Rhode Island's policies with juvenile brain and behavioral development science. Children are particularly susceptible to giving false confessions because they are not as sophisticated as adults when interacting with the criminal justice system and being interrogated by law enforcement. Young people rarely understand the consequences and implications of law enforcement interrogations on their due process rights and the impact they may have on any subsequent legal proceedings. In 2013, the American Academy of Child and Adolescent Psychiatry adopted the recommendation that children have an attorney present during questioning by police or other law enforcement agencies, and also recommended that children should have the right to consult with their parents prior to and during questioning. Additionally, several states around the country have already enacted similar legislation with wide bipartisan support. California, Hawaii, and Maryland have all enacted legislation that requires children consult with counsel prior to any custodial interrogation, ensuring that child status is accounted for in the context of custodial interrogations and that children's constitutional rights are safeguarded. Other states such as Illinois, Oklahoma, Utah, Iowa, North Carolina, and Virginia have created statutory protections to safeguard children's constitutional rights prior to custodial interrogation by passing nearly identical legislation such as this. Thank you.
Thank you for your testimony. Any questions of these two witnesses? Oh, Representative Agello.
Thank you, Vice Chair. Did you get a chance to look at House Bill 5922 regarding custodial confessions, and because it also deals with minors? I'm just wondering if you looked at that bill.
Is that the bill that would prohibit deceptive tactics during interrogation?
Yes.
I have not looked specifically at that bill, but I do know that is also a trend around the nation right now, is prohibiting deceptive tactics during juvenile interrogations.
Thank you.
Thank you. Next. Oh,
Sorry. Mrs. Roberta? Oh, that's it? So do I have a motion to adjourn? Seconded? All those in favor signify by saying aye. Opposed, nay. The ayes have it.